problems without the mic. So this is why I use earphone. Am I audible now?
Yeah,
Yes,
yeah, you.
you're yeah. Good.
Okay. So permission to proceed, Your Honor.
Sure, go ahead.
Okay. The council seeks permission from the bench to collectively address you as Your Honor.
Sure.
Good morning to all present. This is team code 096 and we will be acting as counsels for the petitioner. Now we will be proceeding for the facts of this case. Permission, Your Honor. Okay.
Sure,
The
please.
facts of this case. Yes, sir. Your Honor, were you saying something?
Sorry, I can't hear you. You're cutting off.
Hello.
Yeah.
Hello. Yeah, am I
Can you?
audible now?
Yes, you are.
Okay. The facts of this case, as specified in the moot proposition, are the respondent is a teenager from the city of Mante. On 23rd March 2021, she turns 18 years of age. She reached out to the petitioner with respect to an online advertisement by them regarding a freelance software creation. She told them that she would apply for this role via a phone interview. During the interview, she talks extensively about her experiences and thus is awarded the role. It is important here to note that all contact with her is reported according to company policy. It is equally important to note that the company has a policy of not doing business with minors. Subsequently, she signs a document by the company agreeing to this role. She signs the document and uploads it to the company portal on January 16th, 2021. After this, she is asked to submit the prototype software on April 21st and is told that she would be paid 1 lakh for this. On March 23rd, 2021, she turns 18. On 20th April, a day before this deadline, she asked for an extension. She and the company agreed to allow her to submit this prototype by May 5th, 2021. As of June 21st, 2021, she still has not submitted the prototype. Thus, the petitioners filed a claim for recovery and damages worth 2,50,000. The counsel before you will be covering the statement of jurisdiction as well as issue 1, and my co-counsel will be covering issues 2, 3, and the prayer. Permission from
Sure.
your honor to proceed with is the statement of jurisdiction.
Sure, go ahead.
Okay. For reference, please use page 7 of our memorial. The petitioners approach the Honorable High Court of Monte under Article 226 of the Indian Constitution. The territorial jurisdiction under Article 226 covers all of the territory of Monte, and the subject matter jurisdiction covers the enforcement of fundamental rights or any other purpose. The present claim falls under any other purpose. To support this contention, we rely on the Orissa High Court's decision in Dhansar Engineering Co. Private Limited versus Mahanadi Coalfields Private Limited. In this case, the Odisha High Court admitted an ordinary contractual dispute to be maintainable by it. This was later upheld by the Supreme Court in a 2016 appeal to the same case. The Supreme Court held that existence of an alternative remedy is no bar for jurisdiction under Article 226. This was also retaliated in Haribansh Lal Sinha versus Indian Oil Corporation Limited, Popcorn Entertainment versus City Development Corporation, Union of India versus Tatiana Constructions Private Limited, and Whirlpool Corporations versus Registrar of Trademarks. Thus, we submit to the jurisdiction of the Honorable High Court of Monte. For the sake of brevity, let's retaliate the issues. For reference, please use page 10 of our memorial. Firstly, we would like to contend that the contract between the parties made on April 20th, 2021 is a valid and enforceable contract. Secondly, we would like to contend that there was a breach of the contract by the defendant. Thirdly, we would like to be entitled to damages for the breach, including special damages. Permission to proceed with the first issue, Your Honor.
Sure, go ahead.
Okay. We submit that there was a valid and enforceable contract between the petitioners and the respondent made on April 20th, 2021, according to Section 11 of the Indian Contract Act, that allows parties which are considered majors under Indian Contract Act and under Indian law to enter into contracts. On April 20th, 2021, the respondent was a major and thus competent to contract since she was 18 years of age here. The respondent here made a fresh proposal to allow 2 weeks more to complete her obligations under the previous agreement. Under Section 2A of the Indian Contract Act, when a person signifies to the other his willingness to do or abstain from doing something with a view to obtain the assent of the other party to such act or abstinence, he is said to make a proposal. The company agreed to this proposal according to paragraph 4 and line 5 of the Moot proposition. According to Section 2B of the Indian Contract Act, a proposal, when accepted, becomes a promise. According to Section 25 of the Indian Contract Act, a valid contract also requires valid consideration. The respondents, according to from the respondent side, this consideration was to submit the prototype to this new deadline of May 5th, 2021. This constituted fresh consideration. I would like to pause here to ask if Your Honor has any questions.
So far none. Proceed, please.
Yes, Your Honor.
Proceed, please. No questions.
Okay. From the plaintiff's side, this consideration was a forbearance to sue. As held in the landmark case of Kalishore versus Bischoffman, there was a valid consideration. This is called, forbearance to sue constitutes valid consideration when made in good faith. It also has to benefit the party intended to be sued. Here, the disputed claim was damages under the doctrine of restitution. As mentioned in the Moot proposition, paragraph 5, the respondents did the respondents wanted to recover damages, and recovery, as we know, cannot be made unless there was some amount advanced to them. Thus, under the doctrine of restitution, we would like to the disputed claim here was simply to ask for restitution of the money so advanced by the company to the respondent for restitution. We did not enforce this claim, and this benefited the respondent. Thus, this constitutes valid consideration under Calfisher versus Bischoffman, and this is under the concept of forbearance to sue. This constitutes a valid contract between the parties made on 20th April 2021. Thus, there was a valid contract, and this is our issue one. Permission from my co-counsel to take over, Your Honor.
Sure. Just one question though. So what happens now to the first contract?
Sir, we contend that there was no contract in the first place, since it was simply an agreement. An agreement, the
Because
difference between. Yes, Your Honor.
because you have stated in your memorial there was a novation. So I'm wondering, like, if there was no contract, how a novation takes place.
Your Honor, we have contended that there was a lack of that, there was a not a novation, and we are contending that there was a novation in this memorial. We're contending that there was a novation because there is a fresh consideration here, and this is by virtue of Section 23 of the Indian Contract Act. Would you like me to elaborate on this point, the fresh consideration?
Yes, because my question is, if there is no contract, how a novation can happen? Because only if there is a
Your,
valid contract, then a novation happens and a subsequent contract can be entered in. So if there is
yes, Your
no
Honor.
valid contract according to you, then how a novation can happen?
Your Honor, we're contending that there was an agreement and there is not a novation of the previous contract. We're contending that there is a fresh contract entered into on 20th April 2021. This is because it is not a novation of the previous contract, simply because of the fact that there is a fresh consideration advanced in this contract. This is the consideration in the previous contract was unlawful according to Section 23 of the Indian Contract Act. The Section 23 states that the consideration of any or object of any agreement is lawful unless forbidden by any law or is of such nature that it would defeat the provisions of any law in force. This renders the agreement void. This renders the agreement void and the consideration void. If allowed, the consideration under the previous agreement would encourage a contract with a minor, which is against the provisions of the Indian Contract Act, Section 10 and Section 11. Now, if we thus this by virtue of Section 23, this consideration is void. Thus, this necessitated a fresh consideration in this new contract that was entered into on April 20th. Your Honor, I would like an extension of just 30 seconds to complete this argument. The bailiff says the time is up. Okay.
Sure, sure.
So since
Yeah.
this previous consideration was unlawful, under this new contract, we had to give a fresh consideration so that this contract would be valid. Does that satisfy your question, Your Honor?
Yes, yes. For time being, yes.
Okay, thank
We
you.
can,
I would like to hand over to my co-counsel.
sure.
The council seeks your honor's permission to move ahead with the second issue.
Sure, please proceed.
The council would request your honor to refer to page 14 of the memorial. The council would address the second issue, which contends that there was a breach of contract by the defendant. Ishika had a duty to perform the contract, which has been established to be valid by my co-counsel. However, she failed to perform her contractual obligations and committed an actual breach of contract due to non-performance on her part. In the present case, the defendant promised to deliver the prototype by April 20. With a fresh contract in place, Ishika was provided time till May 5, but she has failed to perform the contract till date. This amounts to actual breach of contract on the part of the defendant. Now, to prove that time was in essence in the present case, the council would like to refer to the case of Orissa Textile Mills Limited and another versus Ganesh Das Ramkishan, where the Patna High Court laid down three principles which can be construed, from which it can be construed that time is of essence to the contract. Number one, if the parties have expressly agreed to treat time as essence to the contract, in case where delay causes an injury, and if the nature and necessity of the contract requires it to be. These principles are perfectly satisfied in the case at hand. If Your Honor would refer to paragraph 2, last line of the moot problem, which states Ishika is told by the company that she must send a prototype of the app by April 21, 2021, and that she will be paid rupees 1 lakh for doing so. This expressly mentions the company's demand to make time the essence of the contract. The fresh contract entered into by the parties was instituted on the same terms and conditions, only with a different deadline of May 5, and hence time was of essence in this contract. The council would like to bring to your honor's notice the case of Dhudar Chandra Goswami versus C.R. Betts, where the court held that if time were not of the essence of the contract, he need not have asked for extension of the time. This request for extension, as made by Ishika in paragraph 4, second line of the moot problem, reveals that the true intention of the parties was to make time the essence of the contract. Such an extension would not have been required if time was not of the essence to the contract.
There
Coming
is
to
one question. Sorry to interrupt you because I'm trying to understand because the fact says that initially the company wanted it to be on April 21st, right? April 20th, 2021, but they agreed to postpone it for 2 weeks to May 5th, correct? That means it's not, it doesn't seem like the time is of essence, right? Because they are willing to have a leeway, right?
time was time was since the beginning the essence of the contract. However, due to the breach, considering the situation at the time, the company gave 2 more weeks because they wanted the contract to be performed because it was essential for the company. It tried to mitigate the loss. It would have made an attempt to mitigate the losses by allowing Ishika to perform the contract even 2 weeks later. However, Ishika again failed to perform the contract.
Right, but my question is because your co-counsel just now said that the first contract was void, so you're claiming that time is of essence was agreed in the first contract. So I'm trying to understand the subsequent contract. Was it also made clear that time is of essence?
In the subsequent contract was basically made on the same terms and conditions as the previous contract with just a different date, and hence the same terms and conditions applied on the new contract as well. So if time was of essence in the previous contract, time will be of essence in the next contract as well, and hence it is contended with applying the three principles that were laid down by the court that time was of essence in this particular case.
Okay, go ahead.
My second principle will be, according to paragraph 4, third last line, the firm had already begun processing work for the app and they had invested a significant amount of money on similar advertising efforts. The company had also had to cancel few meetings with investors for this app because of the absence of the prototype. Here it is evident that the company incurred not just financial injury but also a blot in its reputation, because of which it might lose investors in its future project as well. Hence, the second principle that satisfied the condition of time being essential to the contract, that there should be an injury, is satisfied in the present case. Our third principle, that the nature of the contract requires it to be such that time becomes the essence of the contract, sets true too, since the case at hand is a commercial contract. And it is generally considered that in commercial
Sorry,
contracts,
speaker. I'm sorry to interrupt you. I couldn't hear you properly. There is a static sound going around in the background.
So, may I switch off the fan, Your Honor? Can I take a minute and switch off the fan?
Yeah. No, but I think it's
I'll
not
just.
to do with the fan. I think there is some problem with the system. Maybe Manya or Gargi, can you check what's happening?
Yeah, just a sec. I think it might be my laptop because, but I'm
Okay. Right.
May I start, Your Honor?
Yes, please go ahead.
So the third principle, that the nature of the contract requires it to be such that time becomes the essence of the contract, sets true too, since the case at hand is a commercial contract. And it is generally considered that in commercial contracts, time is the essence of the contract. This was laid down by the court in Odisha Textile Mills Limited in Another versus Ganesh Das Ramkrishnan and reiterated by the Delhi High Court in the 2005 case of Atlas Interactive India Private Limited versus Bharat Sanchar Nigam. Hence here, the three principles explicitly prove that time was of essence in the present contract. Further, in the case of State of Kerala versus M.A. Mathai, quoting Chitty on contracts, the Supreme Court held that a failure to perform by the stipulated time will entitle the innocent party to claim damages from the contract breaker on the basis that he has committed a fundamental breach of the contract, a breach going to the root of the contract, depriving the innocent party of the benefit of the contract. Since time was of essence to the contract and the defendant failed to perform it, it can hence be proved that there was a breach of contract by Ishika. If Your Honor may allow, the counsel would now like to move to the next issue.
Sure, please go ahead.
The next issue talks about whether IROL is entitled to compensation. So according to Section 73 of the Indian Contract Act, which lays down compensation for loss or damage caused by a breach of contract, the IROL is entitled to compensation because, as proved in the previous issue, there was a breach of contract. The breach of contract by Ishika caused loss and damage to the company, as has been established in the previous issue. Hence, IROL is entitled to compensation for the breach of contract under Section 73 of the Indian Contract Act. Now, coming to what degree of compensation can be claimed by the plaintiff, to establish the degree of compensation, the counsel contends that the loss in the present case was foreseeable and could have been reasonably construed as a result of the breach. In the case of Victoria Laundry Limited versus Newman Industries, it was held that only such loss is recoverable as was at the time of the contract reasonably foreseeable as likely to result from the breach. And in Simpson versus London and Northwestern Railway Company, it was stated that in case special circumstances are already within the knowledge of the party breaking the contract, the formality of communicating to him may not be necessary. Here, this being a contract of software, it was reasonably foreseeable that breach would lead to losses for the company. And further, this left the company with no chance of, the defendant left the company with no chance of mitigating the losses. The company spent huge amounts on advertising, processing, and hence, after estimating the various losses incurred by the company, the amount has been fixed at 2,50,000, according to the plaintiff's assessment of damages. Thus, the petitioner requests the court to grant damages resulting from the breach.
Right.
If Your Honor may allow, the counsel would now like to move on to the prayer.
Sure, go ahead.
After establishing that there was a valid contract between the company IROL and Ishika as on May 5, 2021, which was subsequently breached by Ishika, the petitioner hereby humbly prays before the Honorable High Court of Mountain, in the light of the issues raised, arguments advanced, and authorities cited, the court be graciously pleased to declare the contract between the petitioner and the defendant valid, declare that there was a breach of contract committed by the defendant, declare that the petitioner is entitled for damages and recovery of rupees 2,50,000, and or pass any other order, direction, and relief that this honorable court may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the petitioner, as in duty bound, shall humbly pray, all of which is respectfully submitted. The petitioners rest their case. Thank you for lending your time and your much obliged, Your Lordship.
You're welcome. Can we move to the Respondent, please.
Yes, so shall we start?
Yes, please proceed.
Okay. So, Your Lordship, first of all, I just want to start with an objection that, in simple terms, it has been written that it has been mentioned by the opponent counsel that jurisdiction cited by the petitioner in the present case is wrong, as the present case is filed in the civil court of Mante and not in the High Court of Mante. It has been very clearly laid down in the clarification which has been provided by the organization.
Good point. Please proceed. Noted. Sorry, I think she's frozen.
Yes. Speaker one, you're not audible.
Much obliged, Your Lordship. So, the counsel is present before this honorable court in... Am I audible, Your Lordship?
Sorry, I can't hear her.
I can. Can you just repeat something?
Am I audible?
Yes, you are, but your voice is breaking.
Your voice is breaking and you're frozen, actually.
Yeah.
Let me just check my connection. Am I audible and visible now?
Yes, yes.
Yes. Now, can you repeat your points, please? Because I heard it like partially. I was not able to understand your objection. I think I misunderstood your objection. Can you repeat it, please?
Your Lordship, I object, Your Lordship. I object, Your Lordship, that in the simple terms, jurisdiction cited by the petitioner in the present case is wrong, as the present case is filed in the civil court of Mante, and the petitioner has mentioned that it has been filed in the High Court of Mante. It has been clearly laid down in the clarification that they are going to be rectified, and it has been filed in the civil court of Mante.
Okay, I am not aware of the clarification given. But what you said is right in the sense I think the claim amount doesn't fall under the purview of the High Court, if I'm not wrong.
I think the speaker one exited. Just a second.
She has left.
Yeah.
Am I audible now?
Can you speak something? Speaker one?
Am I audible?
Yeah, you are.
I'm so sorry for the inconvenience because I don't know how my laptop has started updating suddenly. So I just joined from my cell phone. Your Lordship, shall I begin?
Yes, please proceed.
Yes. Your Lordship, I was objecting that in simple terms, jurisdiction cited by the petitioner in the present case is wrong, as the present case is filed in the civil court of Mante and it has not been filed in the High Court of Mante.
Okay, proceed. Proceed with your arguments.
Yes. So the counsel is present before this honorable court in the case of company Irol Private Limited versus Ishika from defendant side. The counsel seeks permission before this honorable court to address them as your lordship.
Please proceed with your arguments. We will deal with all these matters later.
Okay. Your lordship, the counsel has duly approached this court under section 9 of Code of Civil Procedure 1908, which states that court to try all civil suits unless barred. Read with section 20 of Code of Civil Procedure, which states that other suits to be instituted where defendant resides or cause of action arises. Now, in the present case, your lordship, there are total 2 issues with which we are dealing. The first issue will be dealt by me and the second issue will be dealt by my co-counsel. Now, your lordship, the counsel would like to take permission from this honorable court to proceed with the facts of the cases.
Proceed.
Much obliged, your lordship. So, Ishika was a 17-year-old girl when she came across an advertisement for freelance development app for the company Irol. Showing her interest in the prospect, she contacted the company and had a conversation with Mr. Siddhartha, who educated her that for taking up this opportunity, she will have to qualify a phone interview round. On 15th of December 2021, she had an interview with the vice president of the company, and she impressed him with her ideas and gets the contract. According to the policy of the company, the interview was recorded. Your Lordship, the Council would like to put your attention on the point that the company had also the policy to not to enter into a contract with the minor. But the company was at fault to have a check on it. The contract was sent through email on 16th of January 2021, and the girl agreed to submit the prototype of the app on 21st of April 2021. And for doing so, she will be paid rupees 1 lakh. For the development of the prototype, Ishika ordered few hardware pieces from China, and there was a delay in the delivery of those hardware pieces. That's why she had to put her work on hold for some time. Your Lordship, the Council would like to put your attention on the point that on 23rd of March 2021, the girl turned 18 years old, which in turn implies that she was not major while
I'm
entering
sorry,
into the
Counsel. Your voice is breaking a lot. I cannot understand your arguments. There is some problem technically at your end.
Am I audible, Your Lordship, now?
You're audible, but your voice is breaking a lot. So,
Is this the same problem with everyone?
no, just with you so far. The other two speakers, I didn't have an issue.
Okay.
Do you have like a external microphone or something? You want to try it with that? If not, let's try. Maybe don't come too close to the microphone, maybe a little bit back. So let's see if it works.
What is happening?
Gargi, I think you should give her a little bit more time because there's a lot of
Yeah,
this
yeah,
technical.
I've paused the timer.
Yeah, good.
Am I audible now?
Yes, please go ahead.
I'm so sorry. I don't know why this is happening. I have
Don't
checked
worry
the
about
network.
it. Don't worry about it. Don't get stressed about it. We have paused the time, so you will get your time. So not to worry about it.
Much obliged, Your Lordship. So, Your Lordship, I was mentioning that on 23rd of March 2021, Ishika turned 18 years old, which in turn implies that at the time of entering into the contract, she was not major. Your Lordship, on 20th of April 2021, she asked for 2 weeks extension so that she can complete her contract. And Your Lordship, I want to point out that my client was suffering from COVID-19. Still, she had no mala fide intention to not to perform her part of contract. She was diligently working for the contract, and hence she asked for 2 weeks extension. And when she asked for a few more days, an additional 40,000 rupees, company denied and filed a suit on 21st of June 2021, accusing Ishika for breach of contract and for the damages of rupees 2,50,000. Your Lordship, now the council would like to proceed with the first issue of the case.
Go ahead, but just one question though. Do you know what's the doctrine or the principle behind requesting for extension based on COVID?
Your Lordship, the girl was the council plead ignorance for this, but the girl was unable to complete the prototype and she suddenly fall ill. Then she asked for extension and she was ready to start working after 20th of April, Your Lordship.
Okay, proceed.
Yes. So the first issue is that the contract in the present case is void. It is humbly submitted that the contract between the plaintiff and the defendant is void ab initio, as the defendant entered into the contract with the plaintiff on 16th of January 2021 and she turned 18 years old on 23rd of March 2021, which proves that at the time of enforcement of the contract, the defendant was a minor. Section 10 of the Indian Contract Act 1872 talks about which all agreements are contract, to which competency is one of the essential factors for the formation of a valid contract. According to Section 11 of the Indian Contract Act 1872, only parties competent to contract can enter into a valid contract. Competency is defined under Section 11 of the Indian Contract Act 1872, which declares the following person to be incompetent. The first one is minor, the second one is person of unsound mind, and the third one is person disqualified by law to which they are subject. Thus, your lordship, it is clear that section 11 clarifies that the defendant was incompetent to contract and hence turning the contract void ab initio. In the case of Ram Ashish Chaudhary versus State of Uttar Pradesh, it was held that in 1977 there was a institute in Uttar Pradesh who appointed few teachers, and while appointing those few teachers, some minors got appointed. So the district basic for education officer of Uttar Pradesh approved them as teachers, but the director of education refused them to give them salaries. So those teachers filed a case. So the Honorable High Court of Allahabad stated that it was held that any contract can be entered into only by a contracting party who is major, and no contract can be entered into by a minor. A contract entered into by a minor is void contract in terms of Section 11 of Indian Contract Act 1872. Your Lordship, in the case of Mori Bibi versus Dharmo Das Ghosh, which is a landmark case, here the Privy Council first time ruled out that contract with minor is void ab initio and declared the law that any contract with minor or any minor's agreement is absolutely void. As your lordship, we all know that the minor are ignorant of the legal obligations. They are not aware of the consequences of their actions because they are not matured enough for it. Your lordship, a minor should not be held liable when he himself is not earning at that point of time, when he himself is getting pocket money from their parents at that point of time. We agree that although the minor was not matured enough for it, the minor was not having experience regarding making the development of the app, but it was the duty of the company that the company should have asked the girl about her experience, about her age. But it is very clear from the clarification number 1 that the company never asked the girl about her age, and the girl not
sorry.
age.
I'm sorry to interrupt you, counsel. Maybe you want to wind up because your time's up. So you want to wind up your arguments and
Yes, your lordship, I'm done.
Counsel. Sure.
Yes, your lordship, I'm done. Actually, I'm unable to see the chat box. Yes. So, your lordship, taking the above arguments into consideration, it is concluded that the agreement signed by both the party is void ab initio and never existed. The defendant, at the time of signing the contract, was minor and was not competent to act upon it. If your lordship is satisfied with the arguments of the counsel would like to call the co-counsel to proceed with the second issue of the case.
Yes, please proceed with the second issue, co-counsel.
Counsel would like to seek permission to proceed with second issue.
Yes, please go ahead.
Much obliged, your lordship. Second issue is that plaintiff is not entitled to sum of damages. From the argument just now stated by the co-counsel, it can be concluded that defendant was just a minor when she entered into a contract. And according to section 10 and 11, minors are incompetent to enter into a contract. And according to landmark case of Mori Bibi versus Damodar Ghosh, it was clearly pointed out that the contract with minor is absolutely void. Therefore, your lordship, plaintiff is not entitled for any type of compensation for breach of contract, as the contract between them never existed. Furthermore, your lordship, by referring to the facts, plaintiff had two major policies: recording the phone call interview, and second, not entering into a contract with minor. The plaintiff only followed policy number 1 and not policy number 2, that is not entering into a contract with minor. As it is clear from the clarification number 1, the plaintiff never asked the defendant about her age. And if they have this type of policy, they should have asked about her age. The defendant and the only logical explanation about all these circumstances, about all these facts, is that they have some ulterior motive or they have some personal gain, your lordship. The defendant, like other children, has dreamed to make new things, and that's the reason she entered into a contract. And as she was getting opportunity, and she was not aware about the legal consequences of not performing the contract. And your lordship, in usual situation, these types of projects are supervised by the particular department of the company and not by the vice president or the top level management of the company. And if the company is investing this much amount in promotional activity and fixing so many meetings for this app, it means this app is of so much importance for them. And council would like to point out the fact from fact sheet para number 1 that she is interested in making new things, and she never said, your lordship, that she had made any prototype or app before for any other company. If this app is of so much importance, they should have asked the defendant about her experiences if she made any app or prototype. On the other hand, your lordship, when defendant entered into a contract, she know that she won't be submit the app on the given date, that is on 21st April 2021, as she was down from the COVID. She asked for an extension and she agrees that she will submit the app on 5th May 2021. And as said by opponent counsel, it is the new contract, your lordship. It is the only extension of the old contract, and till 5th May 2021, it is the continuance of the old contract, and no new contract was formed. And the council would also like to point out the time gap between the 5th May and the 21st June, that is the date of filing the suit. Your lordship, it is almost 2 months. Defendant was just asking for some more time, and they are very capable for giving it. And if if the plaintiff has lost this much amount of loss, that is of 2,50,000 as they are claiming, they haven't waited for such a long period of time. This clearly shows that they have some malified intention in their mind. And your lordship, the plaintiff is not entitled for the remedy of restitution specified under section 65 of the Indian Contract Act, and also specified under specific relief act under section 33, as defendant does not possess any type of good or property, as she was asking additional 40,000 for the completion of an app, as given in fact sheet para number 4 line 7. It implies even if the benefit would have been received by the defendant, is not traceable now. Moreover, your lordship, the present case is for breach of contract and not for misrepresentation or fraud. In the light of above conclusion, it is pleaded that the demand for recovery or damage of this lump sum money of 2,50,000 by the plaintiff is totally unrighteous, and it is totally out of line. Now, your lordship, the council take permission from this honorable court to proceed with prayer.
Yes, please proceed.
In the light of X stated, argument advanced, and authority cited, the respondent humbly prays before this honorable court, be graciously pleased to declare that the contract between the plaintiff and defendant was void ab initio, as defendant was a minor when she entered into a contract, and declare that the plaintiff is not entitled to sum of damages, and pass any order this honorable court may deem fit in the light of justice, equity, and good conscience, and for this kindness the respondent, as duty bound as ever, shall humbly praise. Respondent
Counsel,
rests.
just one question, counsel. So if
Indeed.
I proceed to give the judgment as per your prayer, what happens to the amount paid to the minor or your client now?
Your lordship, as ruled in landmark case of Kangul, if money is traceable, then only the defendant can give the money back. But in our case, as pointed that she was asking for additional 40,000, and they haven't given, and the money which
I
was
can't hear
given
you.
by
Sorry, I can't hear you.
your lordship, as ruled in Khangul versus Laka Singh, if money is traceable, then only the minor is responsible to pay the money. But in our case, defendant haven't got any money, as they are saying only that 1 lakh rupees to be paid after the
Sorry,
completion of.
I have to stop you. Gargi, can you check what's happening with the system? I think there is a problem with the system because I can't hear her voice properly.
No, I'll just check. I'll ask
Yeah.
Kavish about it.
Yeah. Okay, you can start speaking. We will check how your voice is now.
Your Lordship, our client is not responsible to give their money as it is not traceable now. And in landmark case of Ajudia Prasad, Justice Suleiman said that if a minor will give the money back, then it will amount to enforcing the minor's agreement. So our client is not responsible for giving the losses or amount which they have been paid for to the minor. Our client is not responsible.
Okay.
Respondent
Okay.
gesture case, thank you for giving this opportunity.
You're welcome.
Yeah.
All right. Any rebuttals from the plaintiff?
Yes, Your Honor. Can we start?
Yes, please proceed.
Okay. First of all, we would like jurisdiction. I will just drop the link to the clarifications in the chat box. Since Your Honor, you said that you didn't have access to it. So, according to paragraph 5, line 2 of the proposition, the claim has been filed in the Honorable High Court of Monte. The clarifications point out that this was that the jurisdiction would be the Civil Court of Monte. This is the clarification number 1 of the 26th of the clarification on 26th. And time and again, nowhere does it mention district court at all. And the clarification clearly mentions civil court. Thus, we can only conclude by bare perusal of the proposition, as well by bare perusal of the proposition, as well as the clarifications, we can clearly conclude that it was at the district side of the High Court. It was the side
Sorry,
of the High Court
speaker,
of
you have to
Monte.
hold your mic closer to your mouth. I
Am I
think
audible?
a little bit closer.
Yes, Your Honor. Am I audible now?
Yes, better now. Yeah.
Okay. Okay, so according to paragraph 5, line 2 of the proposition, the claim has been filed in the Honorable High Court of Monte. The clarifications time and again state that the jurisdiction is the Civil Court of Monte. And by looking at these two in tandem, we can only conclude that the jurisdiction was the civil court of the civil side of the High Court of Monte. They contended that we have no pecuniary jurisdictions and the amount is lower, is not in the jurisdiction of the High Court. Yet submissions under Article 226 of the Constitution do not look at pecuniary jurisdiction, and that is what we have approached them under. They claim that we never asked her about her experiences, yet paragraph 1 clearly claims that she impressed the vice president because of her experiences. They claim that this is only an extension of the previous contract. Yeah, they have no case law cited for the same, and this is only a bare claim. Our entire issue 1 is proving that this is a new contract. This is what we devoted our entire issue 1 to. The first issue entirely stands on the validity of a minors contract and the minors contract being void. However, we never contended that the agreement she made into while she was a minor, that the agreement she made into while she was a minor is a valid one. We never contended that. We only contended the agreement she went into while when she became a major is the one she should be held liable for. And this is why their entire issue 1 does not holds no merit, and their entire issue 2 rests on the same contention, and this is why the entire issue 2 does not also hold merit, because we never asked her for any liabilities regarding the minus contract. According to, she talked about her vast experiences in the field, and induced the company into believing she was a minor. The agreement signed by her explicitly includes the company policy, and thus by reading the policy and signing the document, she represented that she affirmed that she was not a minor. The company innocently believed her to be a major, and thus constituted to enforce the contract according to due process. Thus, under the equitable doctrine of restitution, Your Honor, can I just ask for an extension to complete my rebuttals? Is that
Yes,
okay?
you can have a minute more.
Okay. Yes, Your
Yeah.
Honor. So paragraph 5, line 2 proves that there was some money advanced to the respondent. And we did not, and thus we rely on Stoke versus Wilson, where an infant had obtained furniture from the plaintiff by falsely stating himself to be a major and then sold part of it. He was directed to pay the amount that was advanced due to this back. This is the equitable doctrine of restitution. They also contradict themselves by saying that we were in dire need. We were in dire need of some prototype or something. However, they also state that we were not able to grant them extension. If we were so in dire need of something, then why would we not grant her an extension? The company innocently all along believed her to be a major, and this is why she did not. This is why she did not. This is why she did not enforce the claim. And
Okay.
also, okay.
Now, I think
They
you should wind up because you crossed your time.
okay. Thank you, Your Honor, for the time.
Yeah. Can we proceed to the defendants? You have
Yes,
anything to say? Yeah.
yes, Your Lordship. Your Lordship, I again object that it has been clearly clarified in the clarification that they are going to rectify it in the new position that they were going to upload, that they're going to change the High Court and they are going to replace the High Court with the Civil Court of Manipur. And if they would have been going to rectify it, that means they cannot that means that would have been the jurisdiction of civil court. Other than that, I just want to say that the girl never made a fresh proposal. She just asked for extension. Why would girl come and ask for that? She wanted to enter into a new contract. She just came so because she wasn't able to complete her project, so she just came and asked that I was not well and I just wanted to have few more days so that she can complete her project. But there was no new contract which was made on that day. It was just an extension. She came and she asked, and the company agreed that okay, you can take 2 weeks and then you can submit the prototype of the app by 5th of May 2021. And other thing, the company never paid rupees 1 lakh. The company was going to pay 1 lakh rupees after the girl after the girl will make the app and will submit them. But the company never made 1 lakh rupees and never paid 40,000 rupees, as it has been clear from the moot proposition. And that's why the girl is not responsible to pay any money to the company. And it is also clear from the clarification that the company never asked the girl about her age. If the company would have asked the girl about her age, the girl will definitely answer them. How can a girl who is just of 17 years of age would have experience about entering into a contract with a company with so big project when they are investing so much of money? If a company is claiming that they have invested so much of money in the meetings, they have invested so much of money in the advertisement and promotional activities, that means it is the duty of the company that they would have asked, but they never asked the girl. And also, it is claiming that the girl concealed, but girl never concealed. It is clear from the clarification that girl never actively concealed her age. The company would have asked, the girl will definitely tell her that what's her age. And also, Your Lordship, uh, even if the girl would have been fraudulently concealed. First of all, the girl never fraudulently concealed, and as claimed by them, that girl has malafidely or fraudly concealed her age. So it is clear from Khalmur versus Lakha Singh that even if from the Mori Bibi and Dharmuta goes, that even if the minor has fraudulently concealed his or her age, then also the minor's agreement will be absolutely void. Your Lordship.
Yep.
Yes, Your Lordship. So this much, and thank you so
Sorry.
much.
Yeah. Thanks. Gary, 5 minutes left. I don't get you.
So they have reserved 7 minutes for rebuttal round, out of which they still have 3 minutes and 30 seconds left if they still have to add anything.
Sorry, I can't hear you.
Sir, I said that they reserved 7 minutes for rebuttal.
I can't hear you yet.
Your
Can the
Lordship?
others hear me?
Yes. Am I audible? Yes. She's saying that we have 3 minutes more, so if we want to add something.
Yeah.
No, your voice broke as well. You said she said, and then it broke off.
They have 3 minutes. They reserved 7 minutes in the start.
Yes.
I
Let
just-
me
Maybe
say,
we do with hand gestures. There is 5 minutes left, but because
Your Lordship,
yes,
am I audible? Yes.
Yeah.
She's just saying
Yeah.
that we have 3 more minutes if we want to add up anything. So I just want to conclude by lastly saying that even if it would have been alteration or novation, So any contract which was void ab initio since beginning, because it was a contract with minor. So any contract with minor, if she had asked for extension and alteration took place or novation took place, the alteration or novation will result into void contract. And also, if they're claiming that it was a new contract, so new contract needs new consideration, fresh promise and fresh consideration. So there was no fresh consideration. It was just 1 lakh which they were going to pay for the first contract, which never ever existed, your lordship. So there was no fresh consideration, and the girl only asked for 2 weeks extension so that she can complete her project and submit them after the 2 weeks extension, because she was diligently working for it. So she had no mala fide intention. With this, I want to conclude. Thank you so much.
You're welcome. I will ask whether Gargi would allow for sub-rebuttals. Do they have the time?
The time has already been up. I mean, the time that they are reserved for rebuttals and sub-rebuttals is already up.
Yeah, sorry then. Speaker 1 of TC 096. I'm sorry. All right. So I think that concludes the session. Okay,
Yeah.
judgment reserved. We will get back to you.
If the judges no further questions, the participants may leave the room.